All right, we do have some breaking news back in court. Now, we do not know what this means, and we are going to be covering it live. I can tell you, if we look in the courtroom, the defense attorney appears to have entered the courtroom. I understand perhaps they are waiting on the judge. Again, this is breaking news. We don't know what it means. We're going to wait to hear. Chanley Painter, who is live in Ohio, is actually going back into the courtroom. So certainly she'll be able to give us some information firsthand about what is happening, but we don't know yet. So I would like to bring in, while we wait, don't go anywhere, because we will certainly be updating you as soon as we have any information. But I have another special guest here with me this morning, criminal defense attorney Vinoo Varghese. Thank you so much for joining us here on Court TV today. I want to turn your attention, if I could, to the testimony that we just watched. And as a defense attorney, how do you feel about knowing that this law enforcement Detective Hitchens has gone back to see the person in jail who has pled guilty and has already said he committed this crime, to try to gather more information about who the female was that made the call to the pizza delivery? What is your thought? How do you feel about that as a defense attorney?
Well, look, the detective, the officer, he's allowed to do whatever he wants to do. I would certainly like to question his motives and spin it. There are some things in the clip, and part of that clip was cut off, but the clip that I watched, he said the prosecutor's leading him and saying something about being a angered lover or something along those lines. And he goes, and the detective said something like, yeah, they usually are. That should have been objected to. I have big issues here with this attorney not objecting to that kind of testimony. And, you know, there are problems with the defense lawyer from the beginning. A criminal defense lawyer has an obligation to not only defend his client in court, but in the court of public opinion. So the quote from this lawyer, the beginning before the trial, was, she believes she's innocent. I mean, talk about mailing it in. Right? You're giving out your view that you don't really believe your own client. And the summation yesterday was, I mean, he could have pounded this, said that, you know, come up with some reason for why the woman said what she said on that phone call. Because aside from that phone call, you have a tremendous, I think, a lot of reasonable doubt in this case. But I don't think it's going to matter, because you're going to get a verdict. You probably already have one, because this is like a Friday. You never want to go to the jury on a Friday, because they all want to go home. They're tired. And the day before Thanksgiving, they're going to be wanting to get out of there. But there's one other issue I wanted to bring up, Judge, which is this. And I don't know if it was made or not. I can tell you that if I were the defense lawyer, I would be objecting strenuously to the use of masks while speaking, right? You can set up this courtroom to socially distance. There's no reason why any of the witnesses should be wearing masks when they are. You got to be able to see their faces and make a comment, and that's important for the jury to see. The jury can wear their masks, right? But there's no reason why the judge sitting 100 feet away has to wear a mask. And certainly you don't want your own client wearing a mask. And as a defense lawyer, I wouldn't want to be wearing a mask. This has come up in some of the jurisdictions up here, and they're accommodating. And I can tell you that this is a due process issue. The ability for the client to get a fair trial. I mean, you have somebody that's, one of the charges was kidnapping, right? So you want your clients to be sitting in a mask. I understand this is COVID and people are there, but if you watch any of the press conferences, Joe Biden, everybody's wearing masks, but when they go to speak, they take their mask off. That should have been done here.
You know what's interesting is I have a live view, so I can see the defendant, just so everyone is aware of what you were watching just a minute ago. That was live feed. The defendant walking around through the courtroom. Now she has come back around, is in the courtroom. To your point, she has her mask on. She's not speaking, so the defendant has her mask. Interesting, it's not a clear mask. Some jurisdictions have made the choice to do that. Here's where we are, just to update you as well as all of our viewers. The defendant is now seated in the courtroom. The prosecutors in the courtroom, the defense attorneys in the courtroom. It is our understanding they are waiting on the judge. As soon as the judge comes on the bench, we will certainly go to court to listen to what is happening. But there is the defendant. She has her hair down today. I know some people notice those things about defendants and how they appear and what they're doing. And here she is with her mask on. Listen, no, I'm going to cut you off when the judge comes on the bench. But in the meantime, I have to ask you this question because you made a comment about, it sounded to me like you were saying, I think that they are going to find her guilty. But it has been 11 hours and 37 minutes. That is a very long time in my experience for a jury to be deliberating, to not have questions or what do we do, judge? We can't reach a verdict. What are your thoughts about the length of time they've actually been deliberating now? And again, I may break you off if the judge comes on the bench.
I think that you have a situation where they're going to reach a verdict. It's the day before Thanksgiving. And unfortunately for the defendant here, this doesn't bode well for her, because on a murder case, you expect the jury to be out for hours, sometimes days, if there was a tremendous amount of evidence presented. Here, there is a lot of reasonable doubt aside from that phone call. So and it didn't help with the O.J. Simpson meme either of 99 problems, but a certain B isn't one. So these are things that it doesn't look good for her. And I would bet my money that they're going to come back with a guilty verdict shortly. And that's probably why everybody's in the courtroom at this point, unless there's a note. I'd be shocked if there was a note.
Yeah, well, you said, reasonable efforts aside from the phone call that was recorded, but the defense attorney in his closing did say to the jury, you need to listen to the whole thing. We know that the jury did request the transcript. That was not admitted into evidence, so they did not receive the transcript, but rather they did receive the recording. So, maybe they've listened to the whole thing. Could there be context in that 3-hour recording that shifts that recording from her admitting complicity to reasonable doubt that she was admitting complicity?
I think that's hard without some explanation, right? And so I think the defense lawyer in his summation said something along the lines that, that this was them plotting to get the kids, but he didn't have an explanation for why at least from what I understand, why his client said those things. Now, she could have given that explanation by having testified. And that some of these jurors, and I can tell you from my own experience, these jurors, some of them are watching court TV. They're not going to admit to it, but they are watching. They're watching and reading about this. And if they heard that there was this big, issue over that she was going to testify and then not going to testify, that obviously is not going to help her. So, I don't think he did enough to counteract that. But, from her point of view, the prosecution made a point about not feeling sorry for her. But I think sympathy is a real issue here. And if there is at least one juror on there who thinks that, why should this woman also go to jail? Because, she was just an accomplice, and the guy who actually killed her is already in jail. Maybe there's a hung jury. We don't know.
We don't know.
I think.
And I just wanted to interrupt while we have this shot that shows everyone, because this is live again. You can see the deliberation clock has stopped. The jury is not currently in that room that I can tell, although that's where they have been deliberating. You see both of the state's attorneys, Ms. Easter's walking behind. You also see the defendant seated at the table next to her defense attorney, Mr. O'Brien. You see, it looks like everybody has their masks on. There are other individuals in the courtroom. Perhaps those are the jurors, because I know they're spread out in the courtroom. I'm just not certain. Again, this is a live shot. We understand the jury was going on a break. Deliberation stopped, and so we stopped the clock, and we are waiting for the judge to come into the courtroom. Certainly, when she does come into the courtroom, we are going to go live back to court. Vinoo, what else? You've raised some really great points. Is there anything else that has really stuck out to you about this trial that sticks in your craw, so to speak?
I think that this is a case that could have been winnable even with that tape. It's just that she would have had to come forward to explain that away. right? Saying that, maybe she was going along, she had a revenge fantasy and was just playing along with it. There had to be some explanation for that tape, because everything else about the prosecution's case actually stinks. I mean, you have the murderer, dialing in from jail. I would have made a motion to have him brought into court. I think that's a confrontation clause violation. There's no reason why he shouldn't be in the courtroom. He's not a child victim, which, often the courts will allow to testify via satellite or whatever, be closed circuit. He should have been there. And he should have been pounded in court.
I just have to stop you there and ask, he should have been there. So let me ask you this. If the reason he wasn't there was because of COVID precautions, restrictions, social distancing, number of staff may be available, I'm making these things up, I don't know the reason. But if those are the reasons, do you foresee an appeal in the future that it is denying the right to confront, even if it's for those pandemic reasons?
Well, let's hope, and I don't have the transcript with me, but let's hope he made an objection to the person testifying from jail on confrontation clause issues. I think it's an absolute appellate issue. And even with COVID precautions, I think you're ultimately going to get to a case like this could go up to the U.S. Supreme Court. And let's assume that was objected to, right? And it gets denied in the Ohio Supreme Court or Ohio Intermediate Appellate Court goes there. You have a court, comprised of people like Neil Gorsuch that will value the Sixth Amendment right to confrontation. And I think that's important to understand. And every defense lawyer needs to be objecting to masks, needs to be objecting to any sort of closed circuit type of testimony. I would still object even with an alleged child victim, but that's usually not going to prevail, but you still make your objection on that ground on confrontation clause issues. But certainly there was absolutely no reason why that, and put COVID aside, you can put him in on one side of the courtroom surrounded by guards, and that's what happens, right? So he should have been there.
It's interesting, though. I'm just thinking through, first of all, I see a lot of attorneys waive presence of individuals, agree to participate even via virtual means because of the pandemic. And you're right, if they waive it, let's just talk about the basic legal premise. If the attorney waives it on behalf of the client, well, then you can't appeal it because you have not objected. You can only appeal things that are properly objected to, ruled on in the record. So that's number one. But number two, I think about the client also, because if you are saying to your client, listen, I think that he needs to be there or else it violates your confrontation clause right, and we want to be able to see him in court in person without a mask. And what if the client says, no, I need this over, I want to go forward with trial? Ashley's maintained her, I'm sorry, not Ashley, that's the victim, I apologize, I misspoke. Erica has maintained her innocence. So frankly, she might be one to say, I don't care if he's there in person or not, I'm going forward. I want this trial to go forward. Attorney, I've heard what you had to say. And Vinoo, I know that you're a good defense attorney, but I'm your client. And guess what? I want to go forward. It doesn't matter to me. And I'm going to stop us there because we see everyone is standing up. We're going back to court live now. I got excited there because there was activity. Vinoo is still with us, criminal defense attorney. There's the defendant. They are all standing as the judge has left the courtroom, and the jury will be probably remaining in the courtroom for their deliberation. And still, let's break this down. If you cannot reach a verdict after a reasonable amount of time, let the court know. But in the meantime, I am instructing you as the jury to go back, to continue your deliberations, and it is your duty to make every reasonable effort to reach a verdict. Vinoo, what are your thoughts on that? Typical, yes?
Yeah, so that's what we call an Allen charge, and the judge gave that. I would have asked, as the defense lawyer, and and I hate to knock on a fellow member of the bar like this, but he should have had that read outside the presence of the jury, and so that he knew what it was. Now, hopefully he knew what it was, but I think Yeah, I don't think he did, because you guys would have been filming it, and that would have been on. You would have shown this, and he should have objected and said, "Judge, look, they can't reach a verdict. Declare a mistrial." Now, judge is not going to do that, but he needed to object, and he hasn't objected, right? Because you guys would have covered it. So that's critical. He just waived a mistrial motion, and we'll see. Because I would be arguing, jumping up and down, Judge, these guys can't reach a verdict, and what you're doing is putting pressure on them to reach a verdict because they all want to go home for Thanksgiving, and that's completely improper. But we're not seeing this, and Stefano is not getting, not getting what she should be getting.
Well, that's really interesting that you raised that point, that there was no objection. Not only that, but that was a short Allen charge. The judge was not very emotional about it, very matter of fact, very much, in my opinion, well, okay, so we understand that you are having difficulty reaching a verdict, but guess what? Too bad, which is the purpose of the Allen charge, to say you need to go back and keep deliberating. Now, it does include the language, which to me is so important, that it says you are not asked to surrender honest conviction, but rather to, have the discussions, use your collective memory and figure out whether or not you all can reach a verdict. Vinoo, this is the part that always is hard for me. At the end of it, she said, if after a reasonable amount of time you cannot reach a verdict, then let the court know. So who decides what a reasonable amount of time is at this point, 11 hours, 37 minutes into it?
That's certainly not a reasonable amount of time. I mean, this is a homicide case. You can expect a jury to be out quite a bit of time on a homicide case. I had a case almost a decade ago in Brooklyn where I defended a guy charged with attempted murder, and the jury took 3 days before a mistrial was declared. So if you're the attorney for this woman, you want to live to fight another day. Any day your client gets to walk out of court, whether it's back, and the case, and there's no conviction, is a victory. So if I were him, I would have just said, Judge, please don't read the Allen charge. Let them continue deliberating, and let's go. And let's come back, let them go for the day. It's Thanksgiving. Let them go for the day. Tell them to come back on Monday. So that's what I would be doing.
Right. And again, didn't mean to interrupt you, but let's look in the courtroom because we just have a short time left. But I'm just observing the prosecutor and defense attorney have been there and they were chatting. Of course, they know each other. They've worked together, so that's not surprising. However, I do wonder if there's any type of discussion at all. And there you see the judge asking a question. It looks like they're asking her a question, probably about logistics. Does the jury come back in here? Who knows? But it may just be some of those things. But I know a defense attorney is never going to entertain a plea at this point in time because it's a pretty good sign for them that they can't reach a verdict at 11 hours, 37 minutes in. Is there any incentive at all for the state to offer any kind of deal at this point, in your opinion?
I think there is, because I'd be concerned if I were them, right? I'm a former prosecutor. I'd be nervous right now as to why these people can't reach a plea the day before, reach a verdict the day before Thanksgiving. It's a little odd, and so they may want to float it. And I actually have to disagree with you a little bit, Judge. If I'm the defense lawyer, if the prosecution offers me anything close to a reasonable plea, I'm going to argue with my client or recommend to my client to potentially take it, because this isn't going to end well for her. I mean, as this day drags on, they're going to get a guilty plea. It'd be shocking if they didn't. So particularly considering some of the issues that I've raised. I also want to go back to something we were talking about, Judge, before we heard from the judge in the courtroom, which was that you talked about the confrontation clause issue. That's not up to the client. That's totally up to the attorney. The client, he doesn't need his client's consent on who he requests to have in the courtroom. It's the issue. The only thing basically at this point in a trial, all matters of strategy are left up to the defense attorney. The only thing that he cannot control is whether a client wishes to testify. So
All right.
that, if client wishes to testify, then he's got a letter. But other than that, the rest of it's his decision.
Vinoo, that's why I love having you on. We are going to have to take a break. Thank you for joining us today, for clarifying that. It's a very important legal point. I do want you to stay with us. Remember, Julie Grant is going to be next, and she will have an interview with the attorney for Chad Cobb. You will not want to miss it. Stay with us here on Court TV, your front row seat to justice.